All right. Good morning, everyone. Looks like it is 9:30 on the dot. And so we're going to go ahead and get started here. Thank you so much for joining me for this conversation this morning, this presentation. So sorry about the late invite. I felt like I was really triumphing and getting out those invitations to you guys early, and June just totally snuck away from me. It was over before I knew it. And I thought I'd sent this out and I was like, oh goodness sakes, what happened here? So I apologize for that. But because of that, I have made extra precautions here to make sure that I am recording this. And so that will be available.
Figure out how to
that will be available for anybody that would either like a copy to just review what happens during this meeting, or if you know of anybody who wasn't able to make it, just let them know. And so for those of you who may be joining us new today, my name is Andrea Harden. I am the Targeted Equitable Relief and Training Coordinator for the Montana Human Rights Bureau. And this is our first Friday little training conversation session that we do on the first Friday of every month. And we try to present new topics to just let people know little tidbits about discrimination laws and the Human Rights Bureau here in Montana. And so today's conversation we're going to be having is to let you know about the protected classes of race, color, and national origin discrimination. And as always, I like this to be pretty informal. So if anybody has any questions along the way, and you're brave enough to unmute yourself, you're more than welcome to speak up. I also have my chat box open here. So if you just want to type in something, I try and keep an eye on that as I move along as well. And I will do my best to answer your questions. Oh, I see Karen's here. Karen always stumps me though. So I'll do my best to answer your questions. We'll just leave it at that. And so without further ado, we're going to go ahead and move along here in our topic today. And as always, I always like to start off with the general things and then move into specifics. So I always think it's really important to understand just what discrimination generally is before we jump into the actual protected classes we're going to be discussing. And so in general, unlawful discrimination is an adverse action taken in a protected area against somebody because they're a member of a protected class. And so that's the definition. And so in order to understand that definition, of course, there's some terms within that definition that's good to understand as well. So when we say that the adverse act or the discriminatory act has to be taken in a protected area, what you see here on this screen are the protected areas. We have employment, public accommodations, governmental services, housing, education, insurance, financial transactions. And so employment is what the bulk of our cases are here at the Bureau. And so keep in mind, if you hear me giving examples and stuff, they tend to kind of go more towards the employment side of things, just because that's what the majority of our cases are. So we have a lot of examples of those. And we do have a contract with the EEOC where we investigate employment discrimination cases under both Montana law and federal law. And so the next thing you need to understand as far as the definition of unlawful discrimination are what the protected classes are. And so here on the left-hand side column, you see MHRA, which is Montana Human Rights Act, and then you see GCFP, that's the Governmental Code of Fair Practices. Those are the two state laws that the Montana Human Rights Bureau enforces. And under those two laws, we have these various protected classes that are listed here. On the right-hand side, we have our list of federal laws. And so you can see that Montana's protected classes are the same and they overlap with the protected classes, but Montana does recognize additional protected classes. We have a few extras, and that includes creed, marital and familial status, and political belief, and federal law does not recognize those. Also note that there is a protected class of political belief, but that is only applicable in the area of governmental services and government employment, anything that the government would have authority over. And then also familial status only applies in housing discrimination. And so now we're going to talk more about the specifics of race, color, national origin protected classes, now that you have the general definitions and understanding of just discrimination. And so race, color, and national origin are protected classes under both federal and state laws. And the federal law that prohibits race, color, and national origin discrimination in the area of employment is Title VII of the Civil Rights Act of 1964. We refer to that a lot as just Title VII. Montana's Governmental Code of Fair Practices and the Montana Human Rights Act, as we just kind of went over, are the state laws that prohibit race, color, national origin discrimination in the various protected areas that we see here as well. And so race, color, national origin, I grouped them together because there are some similarities, but you should understand that they really are, their own separate protected classes. And so we're going to break them down a little bit now. So race is not defined within Title VII, the Montana Human Rights Act, or the Governmental Code of Fair Practices. But the protected class of race has come to include ancestry and physical or cultural characteristics associated with a certain race, things like skin color, hair texture or styles, or certain facial features. And some examples of race would include white or Caucasian, Black or African American, Native Hawaiian or Pacific Islander, American Indian or Alaska Native, bi or multiracial, and Asian. And so now moving on to color, again, the laws that the Bureau enforces regarding this protected class, they don't define the term. But looking at the EEOC fact sheet that's called Facts About Race/Color Discrimination, it says that race and color are not synonymous or the same, but they do overlap. And it goes on to explain that color discrimination can occur between persons of different races or ethnicities, or between persons of the same race or ethnicity. And the EEOC and courts understand color to mean pigmentation, complexion, or skin shade or tone. So based on that, color discrimination occurs when a person is discriminated against based on the lightness, darkness, or other characteristic, color characteristic of the person. And that includes even Caucasian or white people. And so national origin, we do have a definition for this one. The Montana Code defines it as ancestry. And so then when we look over at EEOC guidance, it tells us that national origin discrimination means discrimination because an individual or his or her ancestors is from a certain place or has a physical, cultural, or even linguistic characteristic of a particular national origin group. Discrimination against an individual based on national origin can result from the person's actual national origin, or because the person discriminating perceives the person to be of a certain national origin. And so an example of this would be, let's say that there was some employer out there that refused to hire Chinese applicants during the COVID pandemic. And there was a Korean applicant, but the employer, didn't recognize any difference, and based on that rejected this Korean applicant because this person was perceived to be Chinese. So even though the employer was mistaken and may have hired a Korean, it still has discriminated against the Korean applicant based on national origin. And also, someone can be discriminated against based on national origin, even by an individual who belongs to the same national origin group. And I think another example of that, just because for me at least, it can kind of get buried in the definition, the whole linguistic thing. So if somebody discriminates or harasses somebody because they have an accent, and that accent is characteristic of where they came from, that could be a national origin discrimination as well. And so with all of that, you kind of should have a basic understanding of what is included under the protected classes of race, color, and national origin. And so we're going to look at the types of discrimination cases that are based on these protected classes that we see here at the Bureau. And like always, whether or not someone is a member of the protected class of race, color, national origin is just really the threshold issue. It's the first element that has to be proved, but not the only element. And so discrimination based on race, color, or national origin can take several different forms. These forms, if you've been following these trainings for any time, you've seen these before. And so they include disparate treatment, harassment, by association, indirectly retaliation when somebody opposes or objects to race, color, or national origin discrimination. And then we also have print or circulation discrimination. And so we'll go over these to give you some examples and an idea of how they relate to race, color, and national origin specifically. And so first, looking at disparate treatment, these cases allege that a respondent treated a charging party differently than others based on his or her protected class. And so the first step, as always, in a disparate treatment case is the prima facie case. Prima facie is just a Latin fancy term that means on its first appearance. And the charging party must prove each element of the prima facie case to show that what respondent did, the adverse or discriminatory act, looks like discrimination on its first appearance. And so the first element requires the charging party prove that he or she falls under the protected class of either race, color, or national origin. And next, the charging party must show that he or she was subjected to some type of bad act by the respondent. And lastly, the charging party must prove that there is some type of connection between the membership in the protected class and the act that was taken by a respondent. And so some evidence that raises a reasonable inference include that the act doesn't happen to those who are not of the same race, color, or national origin, or perhaps there were some comments made surrounding the act that suggest that the protected class was a factor in whatever the discriminatory act was. And so when you have a disparate treatment case, the analysis requires a shifting burden. And we just covered in the first step of the analysis that a charging party has the burden of proving elements of the prima facie case. But then after that, the burden then shifts to the respondent to produce what's called a legitimate non-discriminatory reason for the adverse act that it took against charging party. And so once the respondent produces that legitimate non-discriminatory reason, the burden then comes back to the charging party to prove that the reason offered by the respondent is either pretext or unworthy of belief. So the reasons that they gave either just don't make sense, doesn't seem like it can be true, or they use those reasons kind of as a cover to go ahead and discriminate against the charging party. And so in order to prevail on a disparate treatment complaint, the charging party must prove his or her case by a preponderance of the evidence. And this just means that discrimination more likely than not occurred. It's like a 51% versus 49% standard. And this is the same type of standard that is used by civil courts if somebody was to take their case into district court. And just kind of as an aside to let you know that this is out there, the administrative rules of Montana change that shifting burden analysis in the event that there is what's called direct evidence of discrimination. When there's direct evidence, there's no shifting burden, but rather right from the get-go, respondent has to prove by a preponderance of the evidence, again, that an unlawful motive played no role in the action it took against the charging party. Alternatively, the respondent can try and disprove the direct evidence and say that the evidence itself isn't credible or is unworthy of belief. And so relating to these specific protected classes, an example of direct evidence, and this is an actual case that we had, an example would be a text message from a Chinese restaurant manager to a Caucasian waitress that worked there, saying that the owner said she was not needed because a Chinese server was coming in to work every day and Chinese employees come first. So that text message saying that was direct evidence. And so in that analysis, the respondent had the burden to prove that there was no unlawful or discriminatory motive. And so we're going to walk through this shifting burden analysis so that you can see what it looks like in action with an actual case again. And so in this case, a charging party filed a race and color disparate treatment case with the Bureau against his employer, Home Depot, after he was fired by them. And so walking through the elements of the prima facie case, charging party is of African descent and Black, and therefore he was a member of the protected classes of race and color, and he satisfied the first element of his prima facie case. Respondent acknowledged it terminated his employment, and so charging party was obviously subjected to an adverse act, and he satisfied the second element. And lastly, charging party asserted that the other employees outside of his protected classes at the Home Depot hadn't been subject to the same discipline that ultimately led to his termination, even though he asserted that they had violated the same policies. So he asserted he was being treated differently, more harshly. And so based on that, he satisfied the third and final element of the prima facie case. And so then when the burden shifted to respondent, it stated its legitimate non-discriminatory reason for terminating his employment was that he had a long history of discipline for safety violations, and that they went through the progressive discipline, and ultimately that led to the decision to terminate his employment. And so then when it came back to charging party, the burden then shifted back to him. He had to prove that that reason was not worthy of belief or was pretext to discriminate against him. And so in the investigation, first, evidence showed that he did have a history of progressive discipline, and that progressive discipline put him in the final steps subject to termination if he were to violate another safety policy within 6 months. And then he violated another safety policy within those 6 months, causing his termination, according to Home Depot's policy. And then second, he was unable to provide any information or identify any coworkers who violated the same or similar policies without any type of consequence. And instead, the information collected in the investigation, the comparative evidence, actually showed that 3 employees outside of his protected classes received their first disciplinary actions in the form of final warning, so a pretty severe consequence, for the same infraction as charging party. And so ultimately, he was unable to show that Home Depot's reasons for terminating his employment were pretext to discriminate against him, or that they were unworthy of belief. And so the next type of cases that we see here at the Bureau for Race, Color, and National Origin Protected Classes is harassment or hostile work environment. And of course, harassing someone or creating a hostile work environment based on any protected class is unlawful. So that includes race, color, and national origin. And so the legal framework for harassment complaints, it can vary based on what protected area the discrimination happened in. And so as you can see here, I just gave 2 examples of that. We have employment and public accommodation, and I've listed the elements under those. And so you can see that the elements are a little bit different for harassment or a hostile work environment complaint that occurs in employment versus harassment that happens in the area of public accommodation. And so as it relates to the protected classes of race, color, and national origin, generally speaking, the charging party must show that he or she is a member of one of those protected classes who was subjected to either offensive or hostile conduct because of their membership in the protected class. And many times the conduct comes in the form of either comments, inappropriate comments, or unwanted touching. And so after the charging party establishes that, the remainder of the elements left to prove really depend on the protected area that the discriminatory act occurs in. And you can see those differences laid out there. And so I just want to point out the 5th element there in the employment case, how that is applied, a basis for holding the respondent liable. It depends on who was engaged in the harassing behavior. And so, for example, if the harassment is being carried out by a president or an owner, the business respondent is always liable. There's no defense. However, if the harassment is carried out by either a coworker or a non-employee, then the business respondent is only liable if it knew or had reason to know about the harassment and did not take prompt corrective action to stop the harassment. So there is a defense in those types of cases. And so next type of case that we see on occasion is by association. Someone can file a discrimination complaint for disparate treatment or harassment if they are treated differently because of their association with a person who is a member of the protected class of race, color, or national origin. So the person filing the complaint doesn't have to be a member of the protected class. It's just that they're being treated differently because of their association with a member of the protected class. And so an example of this would be a business refusing to serve a Black man because it disapproves of him being married to a white woman that has accompanied him to the business. In this example, the business is engaged in race-based discrimination against the man because of his association with the white woman. And so next up is retaliation. Retaliation is the second highest number of filings that the Bureau receives each year. And so that's why it's always important, I think, for us to briefly go over it, to get the information out there. And of course, retaliation is its own entity or creature, so to speak. It's not really a subcategory of this type of discrimination, race, color, national origin discrimination, because the person does not have to be a member of the protected classes discussed here, or associated with these protected classes in order to be retaliated against. You have the elements here on this screen showing what you have to prove for a retaliation case. This is a prima facie case. And so retaliation is when respondent takes a significant adverse act against a person because he or she engaged in protected activity. So instead of having to prove membership or association with somebody in a protected class, they instead have to prove that they engaged in protected activity. And protected activity includes opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation for disability. And so, for example, if an employee complains to their boss that coworkers are mocking an Asian employee because of his accent, the employee has opposed national origin discrimination and has engaged in a protected activity based on that complaint to the employer. And likewise, if the employee acts as a witness in the employer's investigation into the national origin discrimination of the coworker, then the employee has engaged in a protected activity as well by participating in that. And when you're determining whether or not the charging party was subject to an adverse act, the second element of the prima facie case, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. And so continuing on with the example I gave just a minute ago, if the employer gives the employee who reported harassment and participated in the investigation into harassment a poor performance review or a demotion because the employee engaged in those protected activities, then the employer has retaliated against the employee because it is reasonable to think that a demotion or a bad performance eval could dissuade the employee from speaking against discrimination. And so last but certainly not least, the state of Montana prohibits any printed materials, advertisements, or applications used by employers from either stating or implying that race, color, national origin, or really any other protected class for that matter is being limited or discriminated against in some fashion. So for example, if an employer has an online application that asks as a preliminary screening question whether or not the applicant is from a country other than the United States and rejects an applicant that answers yes, that would be an application that expresses a limitation based on national origin. By statute, the only time employers are allowed to make such statements in print or applications is when there's a bona fide occupational qualification, what's called a BFOQ. And that means that the restriction is based, it's reasonably necessary to the normal operations of business to have that type of limitation. But it's, even though it's in the statute, I don't think that there's any type of situation wherein somebody could make that type of justification for these protected classes. We see this in age, and sometimes there is some type of BFOQ for an age limitation because there are laws out there that restrict people from working certain types of jobs based on age. But this is by statute, but I've been told that there is no BFOQ for race, for example. And even in cases like age where there is some type of BFOQ, under most circumstances, an employer will find it very difficult to establish that it's entitled to that type of defense. And I have a question here. Let's see. Can the engagement in the protected activity be subtle, standing up for someone, or does it need to be formal? I don't think the formality really matters as much. I think what matters most is who is present for the objection or the opposition. And so if they're the supervisors or somebody in authority that stands in some type of position to take some type of action against it, I think has to be aware of the opposition. I think that's what's most key. And so, if a supervisor is present probably and hears somebody saying, hey, we don't tolerate that type of talk in this employment situation or whatever, I think that could probably suffice to be engaging in a protected activity. It can be pretty informal. I think you just have to make sure that they're making that opposition known to the correct people, a supervisor or somebody in some type of authority position. And the example I always give is like, I had a case where there was a charging party who sent what ended up, like if you printed it out, a 3-page complaint letter to HR against his supervisor for a whole bunch of things. And just buried in there, one line was that he saw his supervisor look a woman up and down during a sales call. And so, to me, that's pretty informal. But what was key in that was that he was letting HR know, and that the action he was complaining about, if left unchecked, could be something that would manifest itself as discrimination. It could be harassment if it continued on. So I hope that answers your question. Okay. And so that's the end of what I have for you guys on these protected classes. Hopefully that gives you a basic understanding of the discrimination laws and what some of our cases look like under these protected classes of race, color, and national origin. And of course, we do have more in-depth trainings on some of these topics that we've gleaned over here in this, things like harassment and retaliation. We have in-depth videos over on our YouTube channel. If you go to YouTube and just do a search for Montana Human Rights Bureau, we should pop right up. And so I'm trying to put up videos for that on a regular basis. So check that out. And typically I kind of just follow the same schedule for what we're doing here. So if there isn't a recording that I remember to do like we're doing today, go and check out our YouTube. So there would be past presentations on that as well. Any other questions?
I have a question for you. Are you shocked?
Not at all.
I wrote it down so I remember when we were talking. That would there be a viable complaint for someone that thought that if it was like a reverse discrimination issue, like for instance, I'm thinking of somebody in particular that was hired with a Native American tribe, but they were not of that tribe or of that descent, and they felt like they were treated differently and not promoted because they were not a part of that protected class.
Mm-hmm. Absolutely. I don't really hear, there are certain terms that are out there that I don't really hear come up, at least in my experience with the Bureau. And so like I've never really heard people talk about reverse discrimination. We just apply the laws to everybody across the board. So like, I've heard people at the Bureau talk about how they'll get phone calls where, people will assert that these laws don't apply to them because they're white or because they're male. And it's like, no, that's not the case. We apply these and we look into them and analyze them the same, no matter what their status is as a member of these protected classes. So yes, I think that would be still something that could possibly be a complaint that we would investigate. The only thing I would say in that situation is, and I'm by no means an expert on Indian law or anything like that, but I have been made aware that if things happen within a reservation, and Karen, you probably even know more about this than me, that there is some, we don't have jurisdiction in some instances. So like the example that I've been told is if it's what matters most is who the entity is. So if it's a tribal entity, we probably wouldn't be able to take that type of case. But if it's like a town pump that's on the reservation, then that would still be something that we would look into, if that makes sense.
Gotcha. That does make sense.
Okay.
Yeah.
Yay,
And
thanks for the question.
basically it would be viable because he was treated differently because he was white, not
Yeah.
Native or whatever. And actually he was of a different tribe, which I think is even,
Oh,
treated a
yeah.
little bit differently even than being white. So
Yeah, absolutely. Absolutely. And what I've been told in situations where we have intakes or calls from people who are in the situation where they are, employed or feel discriminated against by a tribal entity, there are the TARO offices. So usually we'll make those type of referrals where we don't have the authority to investigate those types of complaints. We'll tell them to reach out to TARO. Yeah.
Sure.
Yeah, that's interesting. Thanks for the question. Can always count on you.
You're welcome.
Oh, anybody else? No, we're all good. I don't know if I'm supposed to say anything yet, so I might be kind of leaking here or something, but we're in the works of trying to put together for next First Friday a discussion, a presentation. We're not quite sure of the format, with a vice chair from the EEOC. So I'm trying to head off your next question, Karen, which is always what's coming up for next First Friday. So we might have kind of like a detour from my normal format of presenting, we're into the different protected classes now. So we might have a detour from that. There's been some discussion that the topic may be LGBT issues. So just to kind of give you a heads up that if y'all are getting tired of me talking, there's going to be probably a new voice next month. So be sure to tune in.
Excellent. Do you have any like new news in the world of people that are choosing not to become vaccinated, and if they feel like they're being treated
Oh
different?
gosh. All I know is that we're still trying to figure out exactly what we're doing with these types of cases. So we're waiting on, some guidance as far as that, but they are rolling in. So we have been inundated with calls. These people are getting scheduled for intakes with us. So we're collecting information, we're drafting complaints where we see fit. And so, we're going to be figuring out how to apply this type of legislation because yeah, it is something that we're definitely seeing an uptick in, but we're still trying to figure it out is my understanding.
And would that be for employment-based complaints or public accommodations and stuff too?
I'm not quite sure. I can't remember specifically if the legislation itself is only for employment. So I couldn't speak to that. It's been a little bit since I read it, but we are still investigating, and I wouldn't be surprised if we're still not getting some complaints regarding public accommodations and masks as well, because I know that the mandate's been lifted, but some of the businesses are still enforcing that as a a private entity. So I wouldn't be surprised if we're still seeing some of those cases coming in. And I know that some of them are like within our investigatory process right now too. So yeah, it's still an ongoing issue that we're seeing here. Yeah.
Not surprised. Cool.
Yeah.
Thank you so much.
My pleasure. My pleasure. And if anybody thinks of anything down the road, in the meantime, before we get to August, feel free to reach out to me, phone, email. And if you need a copy of this video, that's, let me know as well. I'd be happy to either, I don't know if it'll be too big for email. Maybe I can do it through Teams, or I may just go ahead and post it on our YouTube as well. So you can check that out too, but whatever works for anybody, just reach out to me. I'll get it to you one way or another.
Perfect. Thank you.
Great. Thank you so much, everyone, for joining me. I really appreciate it. And I hope you all have a great long weekend and a happy 4th of July.
You too.
Thank you. Thank you. Take care. Bye-bye.